How you going? Look, I just want to talk about a couple of decisions made by the Fair Work Commissioners whereby they have ruled that the COVID-19 vaccines are safe and effective. They've ruled that in the BHP versus Mount Arthur Colman case. And I'd also like to raise the issue of the Coopers Brewery case where the Fair Work Commissioner Colman basically said that we should not, that we can rely on the ATAGI advice, and I'll quote their words here, because ATAGI is an expert body whose role is to provide evidence-based advice on administration of vaccines to the Commonwealth, right? ATAGI's status as an expert body that provides advice to the government and the public cannot seriously be doubted, and the applicants did not seek to impugn that status. Now, they have, ATAGI have come out a number of times and said initially that the vaccines did stop transmission and were safe and effective. Now, the evidence from the FDA, as early as December 2020, they are on record as saying that there was not enough data available to make a determination about how long the vaccine will provide protection, nor is there evidence that the vaccine prevents transmission of SARS-CoV from person to person. So that was on record in December 2020. My question to you is why are these rulings made by the Fair Work Commissioners are clearly wrong? They've relied on misinformation or whatever. I mean, I accept that they were probably taking the advice of ATAGI. What rights do these people who've lost cases based on this incorrect information have in terms of getting recourse to their unjust decisions?
Senator, as you're aware, we've traversed this a number of times in previous estimates, and a lot of the evidence is on the public record, including through several questions on notice. A couple of them, ECAE 22-046, SQ 22-001-088. But in what I've said in previous estimates, but also in those quants, is that it's not the Commission's role to provide advice on vaccination requirements. We received a significant number of applications to deal with disputes, but also about termination of employment of cases under general protections and unfair dismissals, mainly about vaccination-related issues, and whether or not the employers in those circumstances had provided lawful direction to the employees. Those cases were resolved through the Commission. And then
So is there any recourse for these employees, or isn't there?
Well, there is. They make an application to the Fair Work Commission to have, if they believe that they're being unfairly dismissed, say, they can make an application to the Commission to have their dismissal dealt with.
Again? So can they appeal these decisions?
Yes, they can.
Okay. And the process for that is to go back to Fair Work and ask for an appeal?
It may assist and I might ask Ms Scarlett to provide some further information if you like, but in terms of the case management of unfair dismissal cases, they are, it's our largest case type by volume each year, and they, an application is made by a former employee. They then come into an application is made, comes in, and then the case managed, and then they go to a staff conciliator. The vast majority of those cases are resolved through staff conciliation. Those, if either party is unhappy with the terms if they can't reach an agreement through that conciliation process, then they can have the matter dealt with by a member who can arbitrate matter, and they can draw evidence. They can ask for any documentation. They can take sworn evidence, and then they will apply the law, and then they will apply. So
they can appeal that decision.
And there's a decision that is issued. Those decisions, we've got a section on our website that I haven't checked it recently, but while we're dealing with a lot of these cases, there's a section on our website that provided information around those decisions. But if a party to those decisions is unhappy, then there are appeal rights as well.
Okay. Thank you.
Authorised G. Rennick People First Chermside.